Hey everybody, this is Lee Wind. I'm IBPA's Director of Education and Programs, and this is the Breakout Session 2C from IBPA's Publishing University 2023. This is our makeup session. I have Jonathan Kirsch here. Jonathan, this is publishing law from 30,000 feet. Tell us about it.
Thank you, Lee. Happy to be with you. The title of today's session is meant to convey that we're looking at a lot of landscape from a very lofty perch, which means that we're not going to see a lot of detail. And I want to say that the devil is in the details. When it comes to law and legal documents, general concepts are important and they will guide you through a lot of transactions, but the binding quality of a legal transaction is found in the fine print. So although we're going to take an overview today, each topic that we touch on can be explored and should be explored in greater detail if it arises in your publishing business. I'm going to start with the most important foundational subject in publishing, which is copyright. Copyright is a kind of intellectual property in the sense that you can't hold it in your hands. It's an abstract concept. You can hold a book in your hands, but you can't hold a copyright in your hands. And yet, even though it is an abstract concept, it's fundamental to all media, including the publishing media. Copyright is the right to own and control the use of a work of authorship. It applies to works of authorship in the form of books, but it applies to much else besides movies, poetry, photographs, paintings, sculptures, software. There's really architecture. There's really no end to what is encompassed by copyright. The primary right in a publishing business and the primary right under copyright is the right to make and sell copies of the work of authorship. They might be printed books, they might be ebooks, they might be audiobooks, but they're all governed by this overarching concept of copyright. So we're going to spend a good third of our time together today talking about copyright. We also want to pause and say that I'm talking about the law as it exists in the United States of America. We have our own copyright law. There are international copyright treaties that provide for reciprocity from country to country, but each country has its own copyright law. And so if you're publishing in a foreign country, you need to be mindful of the laws that apply outside the United States. I also should say that in the United States, we have laws that exist at the federal level. Copyright is one of them. We have laws that exist both at the federal level and on a state-by-state level. Trademark is an example of that. And we have laws that exist only at the state level, including, for example, the laws of defamation, the laws of invasion of privacy, which represent not legal assets, not intellectual property assets, but intellectual property risks. So you need to be mindful at any given point, if you're asking yourself or your lawyer, what is the law that governs this situation? It might be federal law, it might be state law, might be a mix of the two. Copyright is defined as the right to protect a work of authorship fixed in a tangible medium of expression. If you stand on the corner and improvise poetry and speak the poetry out loud, you are dedicating that to the public domain because you're not fixing it in any tangible medium of expression. If you're reading from a page, a printed page or a handwritten page of poetry you've composed, that's subject to copyright. If you hired somebody to make a recording, a visual, audiovisual, or audio recording of you extemporizing your poetry, that's fixed in a tangible medium of expression. But it's only when there is a tangible medium that copyright comes into existence. The other point that's very fundamental and often overlooked is that copyright comes into existence automatically at the point that the work of authorship is fixed in the tangible medium of expression. We'll talk about registering copyrights. We'll talk about copyright notices, but under the modern law of copyright in the United States, none of those things are required to create a copyright or to maintain a copyright in existence. Still a good idea to register. It's still a good idea to use proper copyright notices, but the copyright exists whether or not you do. The fixing in a tangible medium of expression can refer to virtually any form of recording or preserving the work of authorship. So for example, if you write your great American novel on a pad, as you put words on the page, that's fixing it in a tangible medium of expression, and the copyright comes into existence. If you still have an old-fashioned typewriter and you're typing it, same thing. If you're working on a computer and you save the file, not if you don't save the file, but if you press save, you now have a digital record that's fixing in a tangible medium of expression as well. And that's a very important concept because it perfects your right of copyright. It brings the copyright into existence. As a general rule, the owner of copyright is the author of the work. So, for example, if you're a publisher and you're dealing in manuscripts written by someone else, and they wrote that manuscript over 5 hard years over the keyboard at their writer's garret, that copyright comes to you as an existing piece of intellectual property that's owned by the author. And then the question for the publisher is, how do I acquire ownership of that intellectual property? The author might hand you a manuscript. The author might send you an attachment to an email that contains the manuscript. That doesn't deliver ownership of copyright. All it delivers is a copy of the work, but not the legal right to do anything with that work. That requires a contract. So we immediately come to the single most important transaction in the life of a publisher. The publisher has to acquire from the owner of copyright some portion or all of the copyright, and it has to be that portion that covers what it is the publisher actually does. Copyright is classically described not as a right, but as a bundle of rights. You can imagine a bundle of sticks. Each stick in the bundle is a different right under copyright. So for example, suppose I've written the great American novel. The right to publish that book, that novel, as a book, printed on paper and bound between covers, that's one of the sticks in the bundle. The right to translate that book into French is another and separate stick. The right to publish that book in hardcover, in mass market paper, in trade paper, in an ebook, in an audio book, each of those is a separate stick. And the sticks, such as they are, can be subdivided. They can be broken up and sold separately. So for example, you could acquire from the author the right to print that book in English in the United States. You could also acquire the right to print that book in English in the UK. You could acquire the right to translate that book into Spanish and sell it in Mexico, or the right to translate it into Spanish and sell it in the United States, and so on, and so on, and so on. There is literally no limit to the rights that you need to acquire for any specific use, and the rights change, grow, and expand over time. So for example, when I started practicing publishing law, there were no ebooks at all, and audiobooks existed only as a form of vinyl recordings, records. So as the technology changes, the number of sticks in the bundle change. This becomes a very important principle when you are acquiring rights from the author. You need to understand, and the author needs to understand, what rights are being conveyed by the author to the publisher. And not only do you have to understand it, you have to agree upon it. And not only do you have to agree upon it, you have to write it down and sign it. In theory, and sometimes in practice, the author will assign to the publisher the ownership of all rights, every stick in the bundle, even sticks that have not yet been added to the bundle. The language that lawyers use is assign all right, title, and interest in and to the work in all media now known or hereafter devised. In other words, it's not only the rights that are in the bundle today, but the rights that are in the bundle 30 years from now when somebody invents a new way of conveying media. There are plenty of contracts in the publishing business, and there have been over history, and I've written many of these contracts that are literally all rights contracts. Every right there is in the book, the work of authorship, is conveyed by the author to the publisher. And what that means is the author is still the author in the sense that he or she wrote the book and deserves credit for writing the book, but doesn't own the book anymore, doesn't own the copyright in the book anymore. It can be assigned in its entirety to the publisher. Somewhat more often nowadays, the sticks in the bundle of rights are broken up and sold separately, so that the author will be assigning some rights and will be reserving some rights. And then they can assign those rights to somebody else. There are also at least 3 different ways for ownership of copyright to be conveyed from the original owner to the new owner. An assignment, the word assign, means to convey ownership. License means to convey the right to use. It's roughly comparable to the difference between selling your house and renting your house. A license is renting the copyright or some portion of the copyright to someone else for a period of time in a specific place, in a specific medium. For example, foreign rights contracts, usually handled by the US publisher to a foreign publisher, but sometimes by the author to a foreign publisher. Those are typically licenses, not assignments. They're typically for a term of years, 5 years, 7 years, 10 years. The assignment, of course, is the conveyance of not the right to use, but the ownership. And the contract needs to make it clear whether it is an assignment or a license. There is a third way for copyright to pass from one person to another person, and that's called work for hire. Work for hire comes in 2 flavors. If you have an employee and within the course and scope of employment, the employee creates a work of authorship, that belongs automatically to the employer. And no writing, no agreement, no conveyance is required. It is part of the employment relationship. And it means that a legal fiction is created. The author of a work for hire is the employer. So in a real sense, you're not conveying anything. It is owned by the employer from the moment it comes into existence. That is, if the employee creates the work of authorship within the course and scope of employment. For example, I'm sitting in Los Angeles. If a sports reporter at the Los Angeles Times goes out and covers Dodgers games and writes stories about Dodgers games, the copyright in those stories belong to the Los Angeles Times because they're within the course and scope of employment. If the same person goes home and writes the Great American Baseball novel at home after hours, apart from his or her work as a reporter, not work for hire. There's a second way you can acquire something for work for hire if you're not dealing with an employee, and that is a work for hire agreement. It's not automatic. There must be an agreement. It must be signed. It must characterize the work as work for hire, and it has to fall into one of several categories of work. So, for example, a novel is not one of those categories. A biography is not one of those categories. If one author sits down and writes a biography from beginning to end, writes a novel from beginning to end, that's not one of the classes that is available for work for hire from a non-employee, an independent contractor. An index is an example. A contribution to a collective work is an example. Contribution to an audiovisual work is an example. And the Copyright Act, which is a statute of law, has the categories enumerated. I'm going to say one more thing about work for hire before we move on. There is a curious feature in American copyright law, which says that no matter what the contract between an author and another party, let's say a publisher, no matter what it says about how long the rights remain with the publisher, sometimes it says for the full term of copyright. That's the life of the author plus 70 years after the author dies. Even if it says for the life of, for the full duration of copyright, the author retains a statutory right to cancel that contract. Now, that right arises decades into the future, 30 years in the future. It requires a great number of formalities. There are deadlines for giving notice. There are deadlines for the actual termination date. It's complicated, it's hard, and there's a lot of ways you can make mistakes and fail to terminate the copyright. But in theory, the author has the right to do so, and the publisher is at risk of losing those rights if the copyright is terminated, no matter what the contract says. The only exception is work for hire. There is no termination right for a work for hire. So, for example, if the publisher wants to acquire ownership of work of authorship without the fear that several decades into the future, they're going to lose those rights, the only way to avoid that termination right is to find a way to make it into a work for hire. And these are, as you can see, strategic issues that the publisher needs to think about and decide in advance, and has to come up with effective documents that will create the work for hire relationship that we're looking for. Now, I mentioned that copyright.
Sorry, Jonathan, can I chime in with a question?
Oh, sure, absolutely, please do.
I'm imagining my hand up in the virtual room. Give us a percent, like out of, like how often does that, decades later termination of authorship happen? Like how real a risk is that?
It's a very, very interesting question. And I'm going to share with you a personal experience. I've been a copyright lawyer, publishing lawyer for, I don't know, now 40 years. I have only terminated one transfer, just one. And it's significant. The transfer that I terminated was for Aldous Huxley's 1984, which is a book of world historical importance. It's a very famous book. People were paying attention when the time arrived and that termination of transfer was available. Most books are not terminated. So I don't want to overstate the risk, except to say that it is possible. And if it happens, you're going to lose rights that you bought and paid for. But it's a very astute question, and I only got one of my own to actually claim. That's how rare it is.
Thank you for clarifying. Keep
Sure. I mentioned previously that as a general rule, copyright remains in effect for the life of the author plus 70 years. That's not the invariable rule. That's the publishing law from 30,000 feet rule. There are many circumstances where works of authorship can go into the public domain, lose their copyright protection sooner than that. And we don't have enough time to drill down in detail on all the different measures of copyright that exist. They apply according to when the book was written, when it was published, when the author died, what year it was published. I'm raising it just so you'll be aware of it. The term of copyright is generally life plus 70, but not invariably life plus 70. I also want to point out that copyright protection has its limits. Even though the contracts that I draft for the author to sign would convey to the publisher all right, title, and interest, including all rights under copyright, including but not limited to all rights under copyright, trademark, and other intellectual property rights, et cetera, et cetera, et cetera. It sounds comprehensive, but copyright does not apply equally to everything that's between the covers of the book. For example, copyright does not protect ideas. It does not protect information. It does not protect words and phrases that are inevitable when you want to describe something, so that two authors describing the same thing have a limited number of words available to them to describe it. If there's an inevitable way to describe a fact or an idea, that's not protected either. The purest and simplistic example I can give you is that recipes are not, as a general rule, subject to copyright, because if I want to write down the recipe for making chicken soup, and you want to write down the recipe for making chicken soup, they are inevitably going to be very, very similar, if not absolutely identical. So that recipes, as a general rule, are not protected by copyright. And these are also examples of example of how copyright doesn't protect facts. The recipe is a list of ingredients. Those are facts. What goes into chicken soup? They're a collection of instructions. How much water do you put in the pot? How long do you keep it in the pot? What do you add to the pot? When do you add it to the pot? Those are facts, not expression. And that applies not just to something as practical and simple as a recipe, but it can apply to virtually any work of authorship that deals in facts or ideas. If there are words and phrases that are the product of the writer's skill and imagination and creativity, they're not inevitable. There are many other ways to say the same thing, but in a less pleasing or colorful or illuminating way. That's where you find copyright protection. There is an exception here too. The copyright law protects something called selection, arrangement, and coordination of facts. So if you exercise the inventiveness and the perceptiveness and the research to find out facts and put them into some kind of table and present them in relationship to each other, the selection, arrangement, and coordination of those facts itself may be protected, even if the facts themselves are not protected. Now, copyright is a coin with two sides. On one side of the coin is the value of copyright as an intellectual property asset that is owned and controlled by the copyright owner. Copyright owner might be the author. Copyright owner might be the publisher to whom the author has granted exclusive rights. But whoever has the copyright has the right to make money from that work of authorship, to produce copies and sell them for a profit. But the other side of and they can prevent other people from doing that. That's the value of being the owner of the copyright. But the other side of the coin is, if you're the publisher and you use something in the book to which you have not acquired the copyright, then you may be at the same time an infringer of the copyright of the image or the text that you used if it belongs to someone else. I have an example that I think is very illuminating. I had a client who published a travel guide. The travel guide was illustrated with photographs that were provided by a photo agency. The publisher went to the photo agency and acquired the right by license in exchange for the payment of money to use those images in the travel book. So on the day that that travel book was published, the images were being used with the permission of the copyright owner. There was no violation of anyone's copyright. The right under copyright was paid for. The book was successful. It went into multiple editions over many years. The text changed. Some destinations were taken out, some were added, but the photographs continued. And one day that publisher was served with a lawsuit for copyright infringement. Case was brought to me, and I said, and the publisher was baffled. He said, I bought and paid for licenses to use those images. I said, let's look at the licenses. The licenses set, and bear in mind, license is the right to use, it's not the right to own. The licenses said, you are granted permission to use these photographs in one book and not more than 1,500 copies of that book, and not for more than 1,500 copies, and not for any subsequent editions of that book. So literally at the 1,501st edition, the first 1,501st copy of the first edition, the publisher was now a copyright infringer. And when he revised the text and published a second edition of the text and kept the photographs, he continued to infringe. And he infringed over a period of several years. That's the other side of the copyright coin. If you have gotten permission, make sure the permission covers what you need and want to do, and make sure you're not using the work of authorship for something you did not get permission to use it for.
Jonathan, in that situation, whose responsibility was it to, was it the publisher's responsibility, knowing they were publishing a second edition, to reach back out to get the rights?
Well, I want to concede, Lee, that there was a certain lying in wait quality to the way this was handled. The photo agency did not send them a reminder, your license is coming. Well, they really wouldn't have had any way of knowing, because they didn't know how many copies had been printed. They didn't know if the book had been revised. So they could, in all fairness, they couldn't have really done much about it. But it's not the responsibility of the licensor to police the license. It would have been the responsibility of the publisher to keep track of what he licensed, for how long, keep track of how many copies he's printing, and then get the additional rights that he needs. That's what the publisher was expected to do under copyright law. However, the fact that the publisher, the photo agency, let this situation go for years, and then when they woke up to it, they slapped him with a lawsuit for these continuous infringements over many years, it doesn't show a lot of good faith on the part of the photo agency.
They could have
But
just
it
sent them a
also-
bill.
Yeah, it's kind of a shabby business practice, but it's not illegal. There is a statute of limitations for copyright infringement. You can't sue somebody for copyright infringements that took place more than 4 years prior to the date of filing of the lawsuit. You can only go back 4 years. It's a rolling 4 years. So whatever falls within the 4-year period, 3-year period, 3-year period is still available for a lawsuit. Let me give you another example. There are predators out there, literally shakedown artists, who will offer image licensing with the intention of monitoring you and then coming back and threatening you with a lawsuit if you exceed the license period. That's really their business model. Their business model is to kind of trick you or trap you into infringing. But again, that doesn't mean they can't do it. They're taking advantage of the fact that the publisher is responsible for obtaining and maintaining the rights that the publisher needs.
Okay, so not to take us down a cul-de-sac, but is there a general system that you've seen publishers use to keep track of the rights?
Yes,
or
there is. But the problem with it is that it requires staff capacity. It requires someone whose job it is to monitor rights and permissions. And now in today's world with digital tools, it's not especially hard to do to enter into a calendaring program when the license expires. If it's measured by years, that's pretty easy to do. And then you'll get a reminder that the deadline's coming up. It's a little more tricky to do it by number of copies printed. But that it is certainly part of a well-run publishing company to know what rights it has and when it's going to lose those rights, and to avoid infringing on the copyright of somebody who was your licensor, even though it can be an added expense to do so. The reality is that I think most independent publishers don't have the bandwidth to maintain a monitoring and calendaring system, or if they haven't been sued for copyright infringement like my client was, they may not even be aware. They might be in their head that this is a possibility until someone springs the trap on them.
Well, good.
But it is definitely a best practice to watch what you're doing, keep a master list of what you've licensed and when, for what it is licensed, and when the licensing period ends.
Super, thank you. Keep going.
I'll give you one more twist on that. Is I've talked about the difference between assignment and licensing. If you buy out the rights, so that you got an assignment of rights, not a license of rights, and it doesn't have a time limit on it, and now they're your images, then what you've done by paying what is inevitably a higher price for the artwork, the photographs, you have taken care of the risk of inadvertently exceeding the scope of your license, because you paid enough to buy them. You're not just renting. That's another approach for rights management. A third approach would be, because not everything is under copyright, is to maintain a library of public domain images that you have the right, and everyone has the right to use because they're in the public domain. And that's you identify them as such, and then you can use them at any time and for as long as you want and for any purpose you want, because once the image has passed into the public domain, it's no longer subject to the rights of a copyright owner by definition. Let me go on a little bit farther down the list. The rights under copyright, and I'm going to bring up what is at this point in our talk, what is probably the hottest topic in media generally and in society generally, including publishing, which is artificial intelligence. There are categories of rights that belong to the copyright owner. One is to reproduce copies of the work, and that's very fundamental. If it's a book, reproducing copies means printing more books. Could also be an ebook, it could also be an audiobook, it could be a comic book. Those are all fall within the reproduction right, the publication right. Another right is the right to prepare derivative works based on the work to which you own rights. So for example, if you buy the right to publish a book, you may also, if the contract says so, you may also have the right to authorize a motion picture studio to make a movie based on the book, or a play based on the book, or a TV series based on the book. And just as the bundle of rights is virtually unlimited, the bundle of derivative rights is also unlimited. As new media come along, they are new derivative rights, and that you may not be the one to actually exploit those rights. A publisher is unlikely to make a movie, but you can, if you own and control those rights, sell the derivative right, for instance, the right to make a movie, to a motion picture company, and that can be profitable. After you've made copies, you have the right under copyright to distribute and sell them, or to lend them. You have the right to perform the work in public. Now, you wouldn't perform a book, strictly speaking, although you might have a public reading of a book, and that's a performance right. And you can display the work for public viewing. Again, that would be more applicable to a painting or a photograph or a sculpture, and not a book, but those are all part of the rights under copyright. The fundamental question that you have to ask yourself is, when you have identified a work of authorship that you want to acquire, you want to find out who is the author, who is the owner of the rights I need. They might not be the same person. And what rights do I want to get? And make sure, and what I'm going to pay for them. And then make sure all of those variables are agreed upon and written down in a contract that has been signed. Then you know what you can and cannot do. Contracts are really the machinery of publishing, in the sense that that's how you acquire rights and understand with clarity what you can do with them and how much you have to pay to do them, do the things you're allowed to do and how long you can do them and where you can do them. That's all what goes into a well-drafted contract. You do not need to have a signed written contract to convey rights. However, you do need a signed document to acquire rights on an exclusive basis. An oral permission, unsupported by a written contract, can only convey non-exclusive rights. It cannot convey exclusive rights. So fundamentally, if you want to be the exclusive publisher of a book, you must have a signed contract or other agreement with the owner of rights in that book. In publishing, there are many examples where the publishing industry, just as a custom and practice, doesn't really insist on signed contracts. For example, it's very common when a publisher is ready to publish a book to send out a request for blurbs by email, to take the blurb back by return email, and to rely on the exchange of emails as evidence that permission was given to use the blurb. Very few publishers go to the trouble of drafting, sending out, and retrieving fully signed written blurb agreements. Now, nevertheless, that blurb agreement, based on an exchange of emails, is binding. But for one thing, it's not exclusive. It cannot be exclusive because it's not a written agreement. And the other thing is that it's revocable. The person who gave you the blurb could write back later and say, I'm withdrawing my permission. Please stop using my blurb. The best practice, as in so much else we've been talking about, is to write it down, get it signed, make sure it says what it needs to say. And then you don't have to worry about it later on. But some things are handled informally by custom and practice, and it doesn't mean you are without rights altogether. Another issue in publishing are what lawyers call formalities. And generally that means, are there notices that should be or need to be or must be published in the book? And are there registrations that must be completed in order to own and protect copyright? And the answer to that question is used to be yes. You used to inject the work into the public domain upon publication if it didn't have a proper copyright notice. That's old law, doesn't apply anymore. It used to be that copyright didn't come into existence until the copyright was registered in the United States Copyright Office. No longer the case. Used to be that copyright was for 28 years and you had to renew it after 28 years. If you didn't renew it, you didn't have a copyright anymore. No longer the case. In today's copyright law in the United States, there are no required notices and there are no required registrations for copyright to come into existence. However, there are still really good reasons why you should use appropriate notices and why you should register. And I want to talk about what those are. It is a best practice at a minimum to put a copyright notice in the book, usually on the reverse of the title page. The benefit you bestow upon yourself by publishing with a copyright notice is that nobody else can come along later and say, I am what the law calls an innocent infringer. I may have infringed on your copyright, but I didn't know I was infringing when I used the work that I saw in your book because there was no copyright notice. I didn't know it was under copyright. An innocent infringer is liable to a very trivial amount of damages for copyright infringement and less than you would pay for a permission. So you don't want to be up against an innocent infringer if you're trying to enforce your copyright. You want to have a copyright notice in every copy of the book that you publish so that everybody knows it's under copyright. That's not a law, but it has a benefit if you do it, a legal benefit. And similarly with registration, you don't have to register it when it's published, but if someone infringes your book and you want to sue them in court, you have to complete a registration before you can file the lawsuit. And there are, what it means is that if you don't register now and you wait until you find an infringer, you can't sue that infringer until you belatedly go to the Copyright Office and complete a registration. What's more is there are certain remedies that you can get only if the work was registered at the time of the infringement. If the infringement took place before registration, those extra remedies, what are called statutory remedies, are not available to you. And the third thing to say is, if you register within 90 days after publication, then you will be eligible for the statutory remedies, even if the infringements took place before the registration. So let's say registration, the infringement was 60 days after publication, and you registered on the 90th day after registration, you're still going to get statutory damages for the earlier, the pre-registration infringements. So these are inducements and advantages to registration and publication with notice. And there's really no reason not to avail yourself of those advantages by registering promptly after publication and publishing with notice. I'm going to spend a little time as our hour wanes on the concept of fair use. Under copyright, the basic principle is you need the permission of the copyright owner to use the copyrighted material. And if you don't have permission, you are an infringer and you're liable to legal remedies, including damages. However, there is a kind of a safe harbor called fair use. And fair use is the limited, narrow use of a copyrighted work without permission that is eligible for a defense, the defense of fair use, if a lawsuit is brought. Publishers, as a practical matter, make fair use decisions every single day. They decide what they can use without permission and what they must get permission to use, and what plausibly falls in between and is defensible as fair use. The problem with fair use is that you never know with absolute certainty whether it's fair use until you get sued and you've raised the defense and you've won on the fair use defense. But there are some things that are such basic custom and practice in publishing that we have a high degree of confidence that fair use does apply. I'll give you the classic example. It used to be, I don't see it much anymore, but it used to be that when publishers sent out review copies of newly published books to newspapers or book reviewers, they would send it with a notice that said, quotations of up to 300 words in a published review of this book are deemed to be fair use or do not require the permission of the publisher. That's a really good example of something that is so fundamentally fair use that it's really not much argument about it. One of the approved uses under fair use is commentary and criticism. A book review is commentary and criticism. One of the another of the fair use factors is how much of the work are you quoting? If you're quoting under 300 words from a book length book, it's probably a small enough amount to be entitled to fair use. Just for the record, the two other tests are what is the nature of the work you're copying? If it's highly fanciful, if it's fiction, if it's poetry, it's less likely to be fair use. If it's factual and historical, it's more likely to be fair use. And then the final of the four fair use factors is what is the effect of your use of the copyrighted work without permission on the rights of the copyright owner? Are you damaging their sales? Can someone get what they want from the copyrighted work by buying your book and foregoing the purchase of the official publisher's book or the copyright owner? These are the four fair use factors. None of them are dispositive in and of themselves. You weigh and balance them. Some you might be strong on one and weak on the other three and still prevail in a fair use defense. And I always regard fair use as kind of the lubricant that allows the gears and wheels of the publishing industry to move. If permission were needed for every single quotation from every single copyrighted work, it would be deadly to the business of a publisher. So we need to rely on, and we do rely on, the breathing room that fair use gives us. On the other hand, if you're averse to defending yourself against an infringement case, there is always some risk in relying on fair use, and it may be prudent to ask for permission rather than rely on fair use to avoid the risk entirely. There's also some techniques for kind of trailing your coat. I encourage clients who want to use quotes from a work under copyright to write to the publisher and show them what they're going to do and ask a question like, how shall we credit this? How shall we acknowledge this? Please give us the notice that we should put on our copyright page. That's a way of showing them what you're doing without conceding that you need permission. And very often you'll get well, sometimes you won't hear back at all. That's very encouraging. Sometimes you'll get a good faith answer. Thank you for asking. Here's the notice we'd like you to use. And sometimes they would say, we think your quote is too long for fair use, but you can use, instead of 300 words, you can use 75 words. In any of those circumstances, this practical communication without the expense of a lawyer may be a good way of eliminating or at least quantifying the risk you're going to face. I'm going to sprint through some other issues, all of which are discussed in my handout in some greater detail than we've been doing during this session. So if we don't get to all of it, I encourage you to take a look at the handout.
And just to remind folks that the handout is available on the Sketch app right near the link to where you are looking, you access this video.
Yeah, and I've designed this handout to be kind of a quick reference sheet. It's something you might want to keep on hand and just run your eye over. It's kind of a checklist. The two things that I want to hit before our time runs out is there is a second big intellectual property right, which is trademark. Copyright protects works of authorship. Trademark protects words and symbols, logos, colors, sounds that are brand identifiers. So, for example, if you're a publisher and you have a logo that's your trademark, only you can use it. Someone who uses it in a deceptive way is committing trademark infringement. You can register that trademark in the trademark office, and you have legal rights to protect it. There are notices you can and should use to identify it. So that's part of the intellectual property asset of your publishing business, your press name, your logo, and other features of the kind of the look and feel of your product line. On the other hand, if you're using a trademark of a third party in a way that confuses the reader as to whether your book is originating with that trademark owner or is approved by that trademark owner, you may in fact draw a claim for trademark infringement. That's the other side of that coin. So you should be aware of what trademarks you own, how to protect them, what notices to use, how to register them. This is mentioned in overview in my handout. And you want to be careful not to use someone else's trademarks in a way that risks an infringement case. There is, however, a fair use doctrine in trademark, just as there is in copyright, and there is some latitude for using other people's trademarks in a way that arguably does not falsely suggest that you are affiliated with or sponsored by the trademark owner. My favorite example is an unofficial, unauthorized history of the Hershey Company, and the name Hershey appears on is the title of the book, Hershey, and then the subtitle was a history of America's favorite chocolate company, something along those lines. But the art director, instead of setting the word Hershey in type, he reproduced a full color photograph of a Hershey bar, which is a trademark. The lettering and the coloring and the configuration of those elements on the wrapper of a Hershey bar is a trademark. And the whole trademark was pasted right on the cover of the book. And Hershey sued for trademark infringement. The case was settled, and the publisher agreed to put a disclaimer on the cover to make it clearer than it was that this was a book about Hershey that did not have Hershey's permission. But the court did not issue an injunction against the book, and that's why it settled, because Hershey was willing to enter into a a more liberal settlement than they would have been if an injunction had been issued. So that's another issue. The final
Like,
thing I'm going to
that
say,
made me think of like how, any press is good press.
yeah, that's right. Well, some progressive companies would say, "Oh, look, we must be an important company. People writing books about us." And it's not like this book said anything all that damaging about Hershey. It didn't say their products were poisonous. It was just a corporate history. But people who own trademarks, as you might imagine, are fussy about them, especially if it's a legacy trademark like Hershey's. I mean, that's like Coca-Cola. That's a very valuable trademark. The final point, it's a big subject for just the few minutes left, is that publishers have three areas of potential liability. One is for libel, which is saying something false and damaging and untrue about someone else or some other company. They have liability for invasion of privacy, which means saying something that is damaging and embarrassing, even if true, and about another person, that invades their reasonable expectation of privacy. Again, these are two sides of a coin. If it's false and damaging, it could be libel. If it's true and damaging, it could be invasion of privacy, but it can't be both. You want to be conscious of the risks you're taking when publishing a book of a claim of defamation or privacy, and that requires making a legal assessment and a legal judgment as to whether what you're saying is defensible, whether what you're saying is true, whether what you're saying is damaging. And then the final big area of liability is what is generally called negligent publication. I've handled a few cases. My favorite one was a book of homemade remedies, things you could make yourself at home with ingredients in your house. One was a suntan lotion. And it turned out that one of the ingredients in the homemade suntan lotion, for which the recipe was given in the book, actually made your skin more susceptible to burning, not less. So someone brought a claim for negligent publication on the grounds that they were actually injured. They got a bad sunburn by using a product that the publisher held out as a remedy against sunburn. You want to be sure that the facts, the advice, the recipes, the instructions that you offer to your reader are safe and sound. One result, if they are not, is a potential negligent publication lawsuit. On my clock, that puts us at full hour.
Yeah, Jonathan, can I squeeze in two questions?
Sure, absolutely.
Imagining
Please.
hands going up in the room that I'm going to try to represent. Social media posts, that's a fixed medium, but it's not owned by the person posting. So what's the rule about that?
Social media is susceptible to invasion of privacy claims, and it is susceptible to libel claims. The question of who's at fault, the person who posts it is potentially at fault. The person who reposts it is potentially at fault. And the person who provides the forum where it is reposted is potentially at fault. Now,
I guess I meant for copyright, not so much for liability.
oh, well, there can be copyright issues too, but you'll see that the terms of use at these social media sites extract from the user permission for reposting. So if you voluntarily put it up there, you are agreeing that other people can repost it.
But a publisher can't grab a social media post and put it in a book that they're publishing without the permission.
No, they cannot. They cannot.
Cool. Also, podcast rights, is that something that you're seeing included in contracts these days, enumerated out? Or
Yes,
is it...
yes, but there are categories. I would say the category that it falls into is audio-visual works. A podcast is really not greatly different than a radio broadcast. It's the medium, the technology is slightly different, but it consists of either words, sounds and images, or just sounds. And there's standard language in a lot of contracts that would pick up podcasts. You could write a contract that says podcast rights are reserved by the author if the author insisted on it. You could write a contract that says audio visual rights are granted to the publisher, including, by way of example, podcasts, just to make sure there's no question about it. That's why a well-drafted contract should anticipate the uses that you're going to make of that book or whatever content you're buying in media now known, but it should also have language that anticipates media hereafter invented. And that language is typical in publishing contracts.
Cool. Any final words before we give you a virtual round of applause?
I want to say one more thing, which is AI is the hot topic. I think I may have previewed this without getting to it. AI is the use of content to educate an algorithm, to educate a computer program, so that the computer program can generate content. And publishers are beginning to get very worried about this. I think as a society, we're getting very worried about this. The law has not caught up with that yet, but my prediction is that if artificial intelligence is used to create content, which is similar to copyright protected content, whose author and owner can be identified, that this will be a form of infringement, just as the use of snippets from musical recordings was initially thought of as something below the radar of copyright, but is now understood to be something that requires permission. I think that AI is not going to open the door to wholesale infringement, but it hasn't gotten yet in the courts and the statutes to a point where we know where AI bumps into copyright law. I predict we will get there, but we haven't gotten there yet.
And I know that one of the issues is that a lot of these companies are training their AI systems with works that are under copyright without asking for permission to do so.
Exactly. I recently saw what I think is the very, very first glimmer in my practice. I can't recall seeing anything like it before. It came in yesterday, as a matter of fact. And it was someone representing an author, asking the publisher to contractually agree that they will not do what you just described. They will not allow anyone to use the content that the author created to train an artificial intelligence software. And I think that's an innocuous commitment to make, as long as you put in the word knowingly. You will not knowingly allow it. But I agree with you, Lee, that these engines are gobbling up content across the internet, and they don't need anybody's permission to do that. It may be unlawful. It may be found to be unlawful later on, but they don't need the publishers to make this content available to them. They're finding the content with their web crawlers.
Yeah, so then it will end up being back an issue about copyright infringement.
That's right. But we'll have to, what I'm predicting, it's not the settled law, is that you, just like in sampling, musical sampling, if you can hear the riff, the chord progression, the sound effect, the words, even if it's just a snippet, you have a basis for a copyright infringement claim. And I think the same principle will apply to AI. If the AI is generating something that is traceable back to a copyrighted work, I think that's going to be the hook on which we handle infringements.
Fascinating. Jonathan, thank you so much. What an
My
amazing
pleasure.
overview. Leading a round of applause for you. And we really appreciate you. Just so folks know, being IBPA members, Jonathan has drafted an annotated publisher contract that is one of the member benefits. You can access that on the member benefits page at the IBPA website. Also, translation, annotated translation rights contract, I believe.
That's right. That's right.
And Jonathan serves as IBPA's legal counsel. As you can see, he knows this stuff inside out, backwards and forwards. And we're always so grateful for you being part of our wonderful community, Jonathan.
Lee, it's my pleasure. Thank you for hosting me.
Of course, my pleasure too. Thanks everybody for watching, and
Bye.
take care.
Bye-bye now.